House Judiciary Committee to order. This is our second meeting. Mr. Clerk, please call the roll.
Representative Banta.
Present.
Representative Bauman.
Present.
Representative Blanton.
Present.
Representative Burke.
Here.
Representative Dietz.
Here.
Representative Flannery.
Here.
Representative Griffey.
Here.
Representative Kulkarni.
Present.
Representative Lewis.
Here.
Representative Maddox. Representative Marzian. Representative Mosier.
Here.
Representative Nemus. Representative Petrie. Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker.
Here.
Representative Williams.
Here.
Representative Wilson. Vice Chair Decker.
Present.
Chair Elliott.
I'm here. So before we get started, I do want to recognize a new member of the committee, Representative Mary Lou Marzian, who isn't a stranger to us here, but welcome. Welcome back. We're so glad to have you. We hope you enjoy your time on the committee, and also want to recognize Representative Wade Williams, who is a new member. Thank you for being here as well. Representative Blanton, I'm going to yield to you to introduce a guest.
Thank you, Mr. Chairman. Members, I'd like to welcome today my district judge from Agolphin and Knott County, Judge Dennis Prater, sitting back there in the back. Judge, raise your hand. Thank you for being here with us, Judge. Could we make him feel welcome this morning?
Thank you for being here, Judge. We appreciate it. So we have 3 items on our agenda, and the first bill that we will take up is House Bill 220, an act relating to driving under the influence. Representative Raymer, if you would come forward. And I see you have a guest and on Zoom. If you'd introduce yourself, and then your guest can introduce himself.
Representative Rebecca Raymer, District 15.
Yes, and I'm Blake Chambers. I'm the Commonwealth's attorney for the 38th Judicial Circuit.
Good morning, and you can proceed.
Thank you, Mr. Chairman. So I'll be brief and then turn it over to my Commonwealth attorney for some remarks. But he brought this piece of legislation to me, this idea to strengthen our DUI laws. And, you know, I'm a mom. I have a 15-year-old that's soon going to be hitting the roads sooner rather than later, thanks to Representative Rudy. And so, you know, of course, I'm worried about his safety and worried about who he meets on the road. So this is something that I think is important for our citizens, for our Commonwealth. Now, I do have a committee sub, and I'll just talk about that.
Please do.
So the committee sub actually looks at our under 21 DUI laws. So currently there was not an escalating fine for that population if you blow below the, I think it's 0.02 to 0.08. So this is just going to have increasing monetary fines, and then it mimics the interlock laws that we currently have for our above 21 DUIs.
There's a motion. Is there a second? There's a second. All those in favor, please say aye. Aye. Those opposed, no. And the sub is adopted and before the committee.
And so what 220 does is it makes the DUI a felony on your third offense. And I'd like to turn it over to my Commonwealth attorney for some comments.
Yes, thank you all for allowing me to appear virtually today for your consideration of House Bill 220, which I believe to be a very important bill for the safety of all Kentuckians and our families on the roadways. As I said, my name is Blake Chambers. I'm the Commonwealth attorney for the 38th Judicial Circuit. I've served as a prosecutor in Kentucky for nearly 14 years, and I've prosecuted thousands of cases. I will tell you, in my experiences of 14 years as a prosecutor, the most difficult and heart-wrenching conversations that I ever have are with families who have had a loved one killed by an impaired driver, or with people who have been seriously physically injured by an impaired driver, especially in situations where that person has prior convictions for driving under the influence. People like the family of Breonna Bratcher. If this bill is successful, I'd ask you all to consider naming this Breonna's Law. Breonna was a 17-year-old high school student in Muhlenberg County. She was going to enroll in Murray State University and be an art major. She lived with her mother and her grandparents and her siblings, and she was just a joy to her entire family. In her trial, where her killer received a 56-year sentence from a jury, I asked probably the dumbest question I've ever asked in a trial, which was when I asked her mother and her grandmother to tell the jury about her. Because how can you tell a jury about a 17-year-old child that is your entire world in the limited time that they had? And how can I tell you today, in the limited time I have, about that young lady? But Brianna lived in Muhlenberg County and went over to Ohio County to spend the night with a friend. And while in Ohio County, she was killed by an impaired driver. That driver had a 0.253 blood alcohol content. He also had amphetamines and methamphetamines and THC in his system. That impaired driver also had 3 prior convictions for driving under the influence. And the most difficult conversation I've ever had in my life as a prosecutor is telling that family that this person, they asked me immediately, why was this person not in prison? Grand juries are confidential, so I can't disclose grand jury communications, but I'll tell you in my career as a prosecutor, I've had grand juries look at me in these situations, wondering and asking, how are these people not already in prison? We live in a day and age of ride sharing. We live in a day and age where every single person has one of these in their pocket. And I believe that the citizens of this community that I've spoken to anecdotally through my experience as a prosecutor, but also Commonwealth attorneys across the state, that we live in a different world today where everybody has a cell phone in their pocket, has ride sharing. There's Uber, there's all kinds of ride sharings for people to contact somebody if they're impaired to not get behind the wheel of a car. And so I'd like to speak to you today about, I know there's some concerns that this bill, in some rare situations, maybe somebody would serve more jail time on a misdemeanor than they would on a felony. Make no mistake about it. In my opinion, in my experience, this change in the law would lead to people serving more jail time and being convicted felons on third offenses. As legislators, you all give us as prosecutors, but you also give the citizens of Kentucky who serve on juries a toolbox to enforce the law. And this would expand the penalties under the law. There may be some very rare, exceedingly rare situations where somebody on a misdemeanor serves a year in jail, whereas on a felony, they may get paroled faster. Those are very, very extremely rare situations, and they exist in every situation where you're looking at a misdemeanor versus a Class D felony. Somebody could steal a candy bar from a convenience store and be charged with theft by unlawful taking misdemeanor, and technically they could serve a year in jail, whereas somebody could steal $2,000 worth of merchandise and be looking at 1 to 5 years in prison on a felony and may get paroled faster. Those are exceedingly rare situations. I think what is important to remember is that this bill would give a toolbox to prosecutors and to juries to expand the range of penalties for a third offense. I believe this bill would keep first offense DUIs exactly the same, second offense DUIs exactly the same. It would just get rid of the third offense as it's written now and take what is written as the fourth offense, 4th or greater, and just change that wording now to 3rd or greater. This is a statute that has built within it a mandatory minimum amount of time. And so I believe that this change in the law would put the power in the hands of the people. It would put the power in the hands of juries to give more jail time in the situations where it's deserved, and in the hands of the prosecutors as well. Those are elected prosecutors, and if the people of this state aren't happy with the way cases are getting resolved, there's only 2 ways a criminal case gets resolved. It goes to a jury and they make the determination, or the prosecutor makes a plea offer, and that prosecutor is accountable to the people. So you'd be handing that toolbox and that power over to the people of this Commonwealth in the situations that deserve it, to give more time in jail and felony status to people who, in this day and age, I believe there's no excuse to get 3 DUIs in a 10-year period with these in everybody's pockets in the world we live in today. And I believe that the public sentiment reflects that as well. I can answer any questions or if Ms. Raymer has anything else, but thank you all for the time and attention that you're giving this. It is very important to families across this Commonwealth. It's important to me as my kids are on the roadways as well. And I think that it's time for this change in the law.
Thank you. There's a motion. There's a second. Representative Blanton, did you have a comment?
I have a question and a comment, and I don't see it on this bill, so maybe when I was talked to, maybe it's on a different bill. This bill doesn't include adding fentanyl to the list, does it, for DUIs?
No, this doesn't address fentanyl.
Okay. Be a good bill to put it on, for sure. The comment is this. From my experience dealing with impaired drivers, if a person's getting a third offense, they have a problem. I mean, I'm going to be very, very frank about it. There's far more people driving impaired that don't get caught than do get caught. So if you've been caught for the third offense, you've got a problem, and you're endangering our families, our communities. And so I'm supportive of this bill, and thank you for bringing this forward. Thank you, Mr. Chairman.
Thank you, Representative Blanton. Representative Marzian.
Thank you, Mr. Chair. Thank you for this bill. I'm supported as well. Is there any way to add attendance, mandatory attendance at AA or NA? Because I think just throwing people in jail and they're not getting any treatment or attending meetings ain't going to help, because when they get out, they'll get their fourth one. So I don't know if you could add that or amend it or any push for that. What are your thoughts?
I can comment on that if you'd like.
Yes,
Ms.
please.
Raymer. Well, I believe under the statute now, if you look at the fourth or greater offense statute, it requires a 1-year mandatory substance abuse treatment program. I believe, if I'm understanding the bill as it's written, all we're really doing is taking that fourth or greater offense statute and changing it to a third or greater offense statute. So that provision in the statute already exists for fourth or greater offense, and it would just apply now to third or greater offense. But it's a great question.
Very good. Thank you.
Representative Flannery.
Thank you, Mr. Chairman. One of the concerns I've had about this, Representative Raymer and I've talked to you about it, is there are several situations where you do actually receive more time on misdemeanors than you do Class D felonies, and I know that's can be kind of confusing and awkward to non-lawyers. Don't necessarily like that myself, but just want to be sure that I've got this correct. The way I'm reading this sub, that under a third offense there would be a minimum of 120 days. Is that correct?
Yes.
Okay. That does alleviate my concern. In my experience, I think that that's actually a pretty high amount on third offenses on how potentially juries might treat that. So I think that does actually help a little bit if we're trying to work around the concern that making this a Class D felony could create a situation where there's less punishment. And then I guess to address Representative Blanton's concerns on fentanyl, 100% agree, and actually have a bill on that. Hopefully it'll be heard next week that will make fentanyl up per se and a couple other substances. So thank you all.
Thank you, Representative Nemus.
Thank you, Mr. Chairman. I have a couple judges and prosecutors from back home watching, and I've been asked the question, what is the reason for the change in the language on page 2 of the committee sub, line 16 and 17 and line 20, where we remove based upon the definition of alcohol concentration in KRS 189A.005? What are we doing there?
That's a good question.
I'm not sure if that's directed to me or who, but
So I'm being told that it was already defined and it was redundant, and that was why.
Okay, I'll check back with him and I'll get back to you, Representative. Thank you.
So we do have testimony in opposition, and that is Scott West, if you'd come forward. Is it opposition con? Good morning.
Thank you, Mr. Chair. I'm Scott West. I'm here for the Kentucky Association of Criminal Defense Lawyers. And there's a whole lot I like about the bill in terms of getting tougher on DUIs. The truth is, the first DUI, the time you spend in jail may be the time that you were arrested before you went to court. On a second DUI, it's a mandatory 7 days in jail. And then under this bill, you would jump from 7 days mandatory to a felony. I want to talk about what happens when you get convicted as a felon. Almost every case is plea bargained. Fewer than 1/3% of criminal cases actually result in a trial. Most of them are plea bargains. And a DUI third, if it's a felony, will likely plea bargain at 1 to 2 years. If it plea bargains at 1 year, it's going to be 4 months to the board, as they say. 4 months for your parole eligible. A serve out, we use the term 721. If you do the math, it comes out to about 7 months, 21 days is a serve out on a felony. On a 2 year, your parole to the board, your first eligibility is 5 months. But under either case, you're going to be probably sitting in the county jail because most Class D felonies are sent to county jail, not to institutions of great size. It's a space issue. And most jails, most regional jails, most county jails have the ability to take Class Ds. So the proposal that I would like to see is retain the 120 days, make it 150 days, where you cannot get out before you serve that time. You're going to serve it in the same place. You're not going to get any different treatment if you get any at all, whether it's a felony or a misdemeanor. But the problem is, you probably won't get anything out. When you get out and you're a felon, you really haven't changed your situation as far as your addiction to alcohol as you did if it were a misdemeanor. But as far as how long should the license be suspended, yeah, roll what the penalties for license suspension in 4 are into a third. You make it mandatory that's beyond what is even the parole eligibility for a felon. But once you make this person a felon, and assuming that they have an alcohol problem, which is one of the easiest things to get addicted to and one of the hardest things to get unaddicted, to manage. I don't think you ever get over your addiction. Once you have a felony, you can't get any government aid. You can't get Section 8 housing. You can't find a job. It's hard to pull yourself back up once it's a felony. And you can be just as hard jail-wise and just as stringent in requiring someone to get help, real help, if you make it a high jail time misdemeanor that is mandatory. Now, this isn't the first time that they've talked about making a third DUI a felony. Back in 2016, they were talking about it, and the compromise was, what we'll do is we'll change the look back. And the compromise was, we'll not make it a felony, we'll change the look back from 5 years to 10 years. Because 10 years, after 5 years, it used to be a DUI conviction would drop off. They doubled the time so they could better find people who had a problem that they hadn't dealt with. The compromise was it wouldn't be a felony. So this is undoing the compromise that a lot of people worked on. And the last thing I want to say is I do think we need more data. I think that, I'm a data file. There's data bills on, and I'm for all the data bills that are on. But we need to look back and see, really, are we doing anything by felonizing, the fourth DUI is a felony? Are those people doing any better because they go to jail? I don't think so. I think they're still going to jail. It's still 120 days. They're getting out after 120 days. They don't have anything that they've gotten in jail to help them. And I think what we need to do is focus on mandatory counseling of substance. Keep them off the road. Take their license for 5 years. Make them have to go 2 or 2.5 years on a ignition interlock before they can drive. do all the things to keep them off the road and to keep people safe, but just making it a felony and hope that that gets their attention won't do it. And if it means that you've got to make a second DUI 30 days, which is what a third DUI is now, a third DUI is a mandatory 30 days, at least you're stepping up and getting their attention earlier. I would rather you fix the 7 days on a second than felonize a third. That's all I had, and if there's no questions, I'll go back to my seat.
Thank you, Mr. West. I was actually here in 2016, so I do remember what you're talking about, and there was a healthy debate on how to move forward. Any response, Representative Raymer or Mr. Commonwealth Attorney? You don't have to, but would give you that opportunity.
I would just state, if you'd allow it, and I want to be respectful of your time, but every single person who pleads guilty to a DUI in Kentucky gets one of these. It lays out the penalties for subsequent offenses. We are dealing with people who are well aware of the penalties as subsequent offenses go up. What this bill is designed to do is to protect families and protect people on the roads. We're having people who are having loved ones die or be killed by people who have read these forms before and simply don't care, it seems, and continue to drive under the influence. This gives us the ability to, if somebody picks up a third offense DUI within 10 years, I believe they've earned that felony. They've been in court twice before and read the penalties, and now they'll be in court every time reading those penalties on the prior offenses, if that makes sense.
Thank you. There's Representative Wilson.
May I ask a quick question to Mr.
Yes,
Chambers?
go ahead.
I agree with you that there's no excuse to ever drive, but what you impaired. But what you just said there made me want to ask a question: would a first or a second offense earn a felony, in your opinion? Because we may come to that point where that's on the table eventually.
I'm a prosecutor, so I'm a little biased, and I think that that's certainly something that should be discussed in the future. But under the law as it is now, I think that this is it's high time for a third offense to be treated as a felony. A first offense, I think, would probably be a little bit too much to felonize, but after a third offense, for sure, this person has been in a court twice. They've already had to do mandatory substance abuse as part of counseling or treatment as part of those two prior convictions. And so I believe a third offense, felonizing that is proper.
Representative Decker.
I think this question is for Mr. West. You talked about revoking a license. I'm not familiar with that ever happening. Is there a law that revokes license?
Well, it's a sliding scale. The more like a fourth one, they take your license for, I think, 5 years. If they haven't changed it, it's been a while since I've ever represented anyone on a fourth. But yeah, and in 2019, we met with people supporting the Intoxilock, the blow, the machines that you have to blow into the car, and but to get them to stop. And they said that what that would do is help reduce DUIs over time. As you get to the fourth, it'll say in the statute how long you have to do that before you can get your license back. An alternative to that, you have to go for a longer period. And it used to be, I think, 5 years before you could get your license back. But, that's an administrative penalty that I think would help people stay off the roads, that doesn't require having to be a felon. You can do that without being a felon.
So is that in this fourth? I don't remember seeing that now the third.
I think what they did in the bill, but I haven't seen the sub, but I don't think it changed anything. I think what they did was they just took the word third out, or took the word fourth out and made that third. And then the license suspension penalties are not in 189A.010. They're in another section.
Thank you.
So,
And if you, and I'm
go ahead.
sorry,
Go
but
ahead.
reply to that. On almost every case I've ever had where you have a fatality when someone has been killed and they have prior convictions for DUIs, you're also going to see another charge on their indictment, and that charge is driving on a DUI suspended license. Breonna Bratcher, who I spoke of earlier, the man who killed her was driving on driving on DUI suspended license, second offense. He had no driver's license. It didn't prevent him from driving. His license had already been suspended from DUIs. It didn't stop him from getting behind the wheel of a car.
Thank you very much. And our last question or comment is Representative Cole Carney. You're recognized.
Thank you, Mr. Chair. I just had a quick question that was kind of raised by all the discussion that we're having here today. In terms of contextualizing the number or the scope of this, I understand the intent and applaud the purpose of the legislation. I just wanted to understand, kind of looking through the corrections impact statement and the cost of incarceration and the discussions we've had around what kind of care these individuals are getting so that they don't, get released and reoffend. What is the rate or percentage, or if you could give any indication on the number of individuals that have, for instance, a second offense, they've gotten their treatment, they've, whatever the penalties were, that are found guilty of a third offense and then a fourth offense. So I just want to understand kind of what the trends are and the numbers are, if they are getting the treatment and, are having to face whatever penalties exist in current law.
I don't have data that speaks to that. Blake, do you have anything to say to that?
I don't have that data either. Just anecdotal what I deal with in my job, but the only people we're dealing with are people who are reoffending. So I'm not sure how many people are successful in not getting second and third DUIs after they get their first, but I do know we see a lot of people continuing to get DUIs over and over again, but I don't have any data on it.
Okay, thank you, Chairman.
Thank you, Mr. Clerk. Please call the roll.
Representative Banta,
Yes.
Representative Baumann,
Yes.
Representative Blanton,
Aye.
Representative Burke,
Yes.
Representative Decker,
Yes.
Representative Dietz,
Yes.
Representative Flannery,
Yes.
Representative Griffey,
Yes.
Representative Kulkarni,
Yes.
Representative Lewis,
Yes.
Representative Maddox,
Yes.
Representative Marzian, Representative Mosier,
Yes.
Representative Nemus,
Yes.
Representative Petrie, Representative Roberts,
Yes.
Representative Stevenson, Representative Whitaker,
Yes.
Representative Williams,
Yes.
Representative Wilson, Chair Elliott,
Aye. House Bill 220 is amended by the committee substitute, passes with favorable expression, 19 yes votes, no votes, and no pass votes. Congratulations. Thank you.
Thank you, and thank you for hearing this legislation.
Thank you. Our next item we will take up is House Bill 136. Representative Baumann. Is he here? Baumann? Oh, there he is. An act relating to corrections data reporting. And if you would introduce yourselves and proceed.
My name is Jared Baumann, representative from House District 28.
Joshua Crawford, Director, Criminal Justice Initiatives, Georgia Center for Opportunity.
Yes, well, thank you, Mr. Chairman. I deeply appreciate the opportunity to present House Bill 136 today in front of the ladies and gentlemen here. I hope you all are having a wonderful day, and will certainly be much brighter on the other side of this committee, I'm sure. But House Bill 136 is going to mandate amendments to KRS 439, requiring that the DOC compile and submit annual reports to the General Assembly. These reports will provide us with critical data on time served by individuals released from correctional institutions and those on parole, promoting transparency and informed decision-making within our state's justice system. It's going to enhance accountability and ensure that policy...
There's a motion on the bill. There's a second. There isn't a substitute. There isn't a substitute, correct?
No, sir.
So we need a motion on the bill. So I'll take it. That's a motion and a second. Do you want to continue, or
No, sir.
your guest
Thank you.
may have a few comments since he made the drive up in the snow, right?
So in discussing the shortcomings of the criminal justice system, former New York State Supreme Court Justice Harold Rothwachs once said that we are dealing with the most important thing in a democratic society. We are dealing with the location where the government acts upon the individual with the intent, often, to deprive him of liberty and sometimes of life. Nothing should be more sacred, more important, more deserving of our respect, more expressive of our values than the criminal justice system. I would also add that it's the primary mechanism by which governments protect families and keep communities safe. As the voice of the people, the General Assembly has been tasked with building and tweaking this system. Doing so means adhering to timeless truths and making changes cautiously, because the stakes are in many ways higher and can literally be life or death. Unfortunately, here in Kentucky, our ability to assess and make changes to our criminal justice system too often has to rely on anecdotes and incomplete data. This is what House Bill 136 seeks to address. It aims to enhance accountability and ensure policymakers have access to comprehensive corrections data, including length of stay for first-time offenders and a wide array of parole data and supervision outcomes related on a number of factors that we don't currently collect.
Thank you very much. And I think this is an important bill because data really informs everything that we do here as policymakers. And if we don't have good data, I think it's very difficult to make good policy. So I appreciate you bringing the bill forward and trying to get to all of the numbers and how folks are doing after they're leaving incarceration is very important. Any comments or questions? Representative Burke.
Thank you, Mr. Chair, and thank you, Representative Baumann, for bringing this bill. I do think we need to know better what happens after someone's released so we can determine how to make sure they don't reoffend. My question relates to the putting this in practice. Has DOC expressed that they can pull this together, or have they expressed any reservation about their ability to do this? Because we need them to do it.
We do. Thank you for your question, Representative Burke, and they have not expressed any concern at all. Thank you.
And they're already submitting a report as it stands now under current law. Is that right, Representative Baumann?
This is going to formalize that report and establish the criteria that we want the General Assembly to receive. Yes, sir.
Okay, that's what I thought.
The specific data that's requested here is also already collected and published in report format by a number of other states as well. It's not a particularly novel approach.
Okay. So there's a motion, there's a second. Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Baumann?
Yes.
Representative Blanton?
Aye.
Representative Burke?
Yes.
Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery? Yes. Representative Griffey?
Yes.
Representative Kulkarni?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative Marzian? Yes. Representative Mosher?
Yes.
Representative Nemus? Yes. Representative Petrie? Representative Roberts?
Yes.
Representative Stevenson? Representative Whitaker?
Yes.
Representative Williams? Yes. Representative Wilson? Yes. Chair Elliott?
Aye. So House Bill 136 passes with favorable expression, 19 yes votes. Congratulations.
Thank you, Mr. Chairman and ladies and gentlemen of the committee. Thank you.
Thank you. And the last item that we will take up this morning is House Bill 201, Representative Matt Lockett. an act relating to theft of services. And if you would come forward, you do have a committee substitute, and we'll take that. I may have you explain the changes in that before we adopt it, but if you would introduce yourself and your guest.
Thank you, Mr. Chairman. Good morning. My name is Matt Lockett, State Representative from the 39th District out of Jessamine and Fayette County.
Good morning. My name is Ian Goff. I'm a business owner from Jessamine and Fayette County as well.
We did also have someone on Zoom. I don't know if he has logged on or not.
I am on here, Representative Lockett.
Okay,
Can you
great.
all hear?
Yes.
Good morning.
Could you introduce yourself, Mr. Ross?
Yes, I am Joe Ross. I am the Logan County Attorney, and I am the president of the Kentucky County Attorneys Association. And we are kicking off our conference today, so I thank you all for letting me appear virtually so I can be in two places at once.
Thank you, Mr. Chairman. There is a committee sub, and
There's a motion. All those in favor, please say aye. Aye. Those opposed, no, and the sub is adopted. Would you explain how that changes the bill?
Yes, sir. So the original bill, House Bill 201, is the exact same bill as House Bill 95 from last session, which we actually passed out of the House with a unanimous yes vote. It was not taken up in the Senate due to some wording that the County Attorneys Association had some conflict with. So we came back over the interim, changed some wording. The main difference is it changed where the wording is located. So the original House Bill 201 / House Bill 95 from last session had this language in the theft of services, which is located in KRS 514.060, and moves it to KRS 5.14.070, which is simply theft. And so I will let my guest kind of describe the reasoning for the bill, and we'll go from there.
Thank you very much. So as rental store owners, one of the things that we encounter is someone comes and rents a piece of equipment. They come in, they say, we're going to rent it for a day. They pay for it. They leave. We run their credit card or whatever their payment is. End of the next day, no piece of equipment comes back. We call the customer. We might get an answer. We might not. And then maybe it's 2 days later, maybe a week, maybe 2 weeks after that. Either a cousin, a brother, somebody comes, they drop the piece of equipment off. We check it back in. We say, okay, well, this rental agreement was for 1 day. It's now been 2 weeks. Well, they just sent me back with a piece of equipment. I don't have any money. So now as owners, we've lost our ability to rent that piece of equipment for that period of time. And there's been no recourse that we've had. And we've had members who have tried to take this to their county attorneys. And rental wasn't held in the wording of the language. And what this bill does is it gives us the ability to say, this is a crime in the state of Kentucky. And if you commit this, if you commit these actions, these are the recourses that can be had. And we've worked with the county attorneys, and they've really helped us to form some language that puts up barriers and protects us as owners and allows us to tell people up front and have it posted in our stores and say, hey, if you do this in the state of Kentucky, this is not allowed and this is what can happen to you.
Is Mr. Ross?
Yes, and I would say I've been a county attorney. This is my 15th year, and I've been a prosecutor since 2007. Just looking at the scenarios that these gentlemen described when I met with them, I started off looking at this scenario, and specifically Mr. Goff describing a situation where it would make me pursue this as a general theft provision because he has an item that 2 weeks is generous to some of the situations he was talking about. And there is a statute out there that would allow law enforcement to start reviewing that as a general theft, which helps him in a way that if it is considered stolen, they can start searching for that item, potentially return that for them if the circumstances allow. But the issue comes up is what do we do when it's returned? Under the general theft provisions now, there would be no recourse. So essentially what this would do would create a situation where a legal phrase that's often used by criminal practitioners would make this sort of a lesser included criminal penalty for those situations that Mr. Goff has described. So those people who intentionally rent something for one day, hold for more than 5 days, and then bring back, they would be criminally responsible still for a misdemeanor offense, giving them a deterring effect and letting people know this is illegal and a crime. A big issue that we had as contemplated in the initial bill had to do with restitution. The restitution and the theft of services statute, we had concerns with its applicability in those situations where the actual item is returned. So in a meeting that I had with the Renters Association, we agreed that we would limit restitution to those situations where the item wasn't returned, but still give them specific relief that they could seek as a civil remedy for those lost opportunity costs. I have shared this with my association, and we feel this is or my board at least, are going to talk about it with my association later today. We feel this is a good compromise to meet the needs of all those involved. And I thank the renters for coming to the table, and it was a very nice meeting we had a couple of weeks ago.
Thank you very much, Representative Flannery.
Yes, I can remember this bill last year, and I guess I did vote for it, but I don't understand why the current statute's not sufficient, either under the original bill or the committee sub. I know one deals with general theft and theft of services, but why is the current law not sufficient to deal with this?
I think the concern from several people would be that once the item is returned, that there is no longer a theft. I would agree with you that there is a statute that would definitely provide a basis to start that investigation, but I think the concern would be whether you could get a conviction on the back end of that. But let me pull that up. 514-020 in the general provision section does make it a crime or prima facie evidence of a theft to keep longer than 4 days intentionally. I think this would just provide a secondary option in those instances where it is returned, and a little bit easier to meet all of the elements that you might have at the beyond a reasonable doubt phase.
All right, thank you.
And
Representative Moser.
Thank you, Mr. Chairman, and thank you for bringing this bill. I understand the frustration that you must feel when you have this situation, so I think it is important to talk about it. But my question is, isn't there recourse in a contractual agreement with the renter? I mean, you rent a car and they put a hold on your credit card in case you don't return the car in time. I mean, do we need to create another crime when it could be handled through a contractual agreement? And of course, if the person, absconds with the equipment, and I mean, that's absolutely a theft, but I'm just wondering why this isn't handled contractually.
Thank you very much. I appreciate the question, and I wish we were dealing with people all the time that would abide by the contract. And what happens more oftentimes than not is it'll be a prepaid type of card where we'll run it for the original transaction, and then when we go back to it to run it again, there's no funds available. Or we've had it before where people will go back and we'll run the card and they'll go back and they'll cancel or they'll contest the transaction. 9 times out of 10, we're unable to win even with a signed contract. The credit card company is always going to side with the card member. So that's been a situation that we've run into multiple times there. And I wish we were always dealing with clients that were honest and upstanding and wanting to do the right thing. And most of our clients are that way. And those are the people we want to do business with. But inevitably, from time to time, we fall into a situation where we're working with a bad apple. And what we're really trying to do here is prevent these people from committing this crime and taking away our ability to make money and rent our equipment.
May I follow up, please?
Yes, go ahead.
Just quickly, putting a hold on someone's credit card, I mean, you really have protected yourself, maybe not for a month, but, I understand the concept here. I understand what you're trying to do, and I agree with it. I just think that, you can put a hold on someone's credit card and get the money essentially up front if they don't comply with the terms.
And we put it on for the terms of the contract. So if you came in and rented a piece of equipment and you rented it for a week, we would go ahead and run it for that. Okay. It's the people who are not returning the piece of equipment and they're keeping it beyond that. And we would call you and say, is the piece coming back, or would you like to extend the rental? And our hope is always that you want to extend it and keep it longer. That means you're continuing on your work and we're continuing to rent. But it's the ones who keep it beyond that, and that contract was stated for that amount of time, so that hold wouldn't allow us to keep it when it's contested, or if the funds are no longer available, then we're not able to win that claim.
Yeah, it seems like you would be able to say in the contract, if you keep the equipment longer, you're going to be charged a daily rate or, an assessment on top of that. So, all right, thanks.
Thank you.
Representative Williams.
Thank you, Representative Lockett, for bringing it. I think looking at this from a practitioner, from a law enforcement perspective, I would interact with these situations very often, and your hands were kind of tied because the first thing that came out of everyone's mouth is this: "Oh, it's a civil matter, and you can sue them for it." And you can probably testify how successful that is. You're not going to be able to find somebody for civil court, serve them the papers, run the equipment down after it gets pawned and after it gets sold and after it goes through multiple layer of hands. So I think this is a great tool to give the law enforcement officers the ability to act more quickly on it, and I think it's a good bill, and I'm fully supportive of it.
Motion and a second. Representative Burke.
Thank you, Mr. Chair. This question is actually for the Zoom guest. I'm hoping, sir, that you could help me understand how this differs from or why it's needed in addition to KRS 514070, theft by failure to make required disposition of property. It seems that they haven't returned the property, but this person has. But why couldn't we use 070 to prosecute in this situation?
I think it's for those gray area situations where the item gets returned shortly thereafter, and you're talking that we're going after the people that you would have a hard time proving they had an actual and long-term intent to deprive, but more the situation where you have people who intend to return it but are intentionally trying to avoid their contractual terms and trying to basically get a week's worth of rentals for the 1 day rental. But I do agree that a lot of these situations are going to be, in our mind, are probably going to fall under the theft statute. This just kind of has something for that in between where they are intentionally holding over for a purpose of using it without honoring those terms.
Thank you very much.
Thank you. There's a motion, is that right? There's a motion and a second on House Bill 201 as amended by the committee substitute. Mr. Clerk, please call the roll.
Representative Banta?
Yes.
Representative Baumann?
Yes.
Representative Blanton?
Aye.
Representative Burke?
I'm going to pass, but I'd like to explain my pass.
Yes, go ahead.
I think this is a good idea. I just really want to compare the statute I referenced with the one you have to make sure that I feel that it is completely necessary, but I am generally in favor. Thank you.
Representative Decker?
Yes.
Representative Dietz?
Yes.
Representative Flannery?
Yes.
Representative Griffey?
Yes.
Representative Cole-Carney?
Yes.
Representative Lewis?
Yes.
Representative Maddox?
Yes.
Representative Marzian? Representative Mosier?
Yes.
Representative Nemus? Representative Petrie? Representative Roberts?
Yes.
Representative Stevenson? Representative Whitaker?
Yes.
Representative Williams?
Yes.
Representative Wilson, Chair Elliott,
Aye. And Representative Nemus has come back into the room. Oh, is it? There's a title.
Motion on the title.
We have to, okay. So with 17 yes votes and no votes, House Bill 201 is reported favorably. Is there a motion to?
Second.
It's adopted. Do I need a vote? Aye. All those in favor, aye. Aye. Those opposed, no. It's adopted. So that's all the business we have for this morning. Any other members seeking recognition? If not, we'll stand adjourned.